Hi guys, it's Kathy. I hope you're doing well. I'm sorry I just screamed at you. I just screamed at you. Hi guys. Hi. I'm so glad you're here. It's okay, Josh. It's not delicious. It's okay. I don't know why. They did something to it. Sort of tastes like, I don't know, like, you know when you put way too much milk in your coffee and it has that taste that I can't describe? That's what it sort of tastes like. Like there's way too much milk in the coffee. I like coffee. I love coffee. I do. And I don't mind if the coffee is flavored, but I'm more here for the coffee. You know, just like when I eat French fries, I have a little bit of ketchup. The French fry is not a ketchup delivery device. It's just a little bit. I like potatoes a lot. Potatoes are delicious. Not coffee and potatoes though. Do you know? So I live in Lancaster, Pennsylvania. Pennsylvania Dutch food, a lot of Amish. Okay? So there's this one dish that I haven't not tried. I don't know if I'm ever going to try it. And it's called coffee soup. It's not what you think, but it's not any better than what you're thinking right now. Okay? There's a lot of different ways you can make coffee soup. And a lot of different ingredients, alright? But the basics. So, Mary, maybe you've had coffee soup before. The basics of coffee soup, the basic recipe is you heat up milk. You know, sort of until it gets the skin on the top. And then you add some instant coffee. Not a lot. I mean, you're not making a cup of coffee. You're just using a little bit of the instant coffee and a little bit of sugar. Remember I said sugar later. You're going to need that information. And then you take saltines, crackers, and this is a cereal debate right here. You know how some people put the milk in and then put the cereal in, and other people correct people, sane people, put the cereal in and then put the milk in. Listen, if you're putting your liquids in first, you need to go seek therapy. So you put the saltine crackers in a bowl, and then you pour this coffee milk on it. No, I won't be participating in this meal. But then some people use bread, some people use croutons, but traditionally it's just the crackers or stale bread. And then a lot of people put meat on. They'll fry a burger patty. They'll put, bacon or sausage on top of that. I remember I said there was sugar in it. So no. See, this is why I can never be Amish. Nope. I love the pretty dresses, but I'm not eating soggy bread. Ugh. I can't stand. You know how Jersey Mike's, they want to drown your bread in that, I don't know what it is. I think it's vinegar and oil. I don't know. Ugh. I can't do soggy bread. And here's why I think I can't do soggy bread. Growing up, I went to Catholic school. 12 years of Catholic school. And we did a large amount of sub sales. For basketball, for the school, for this, for that. Sub sale. So we were always buying all these subs. Now back then, they didn't separate the tomatoes and the lettuce and the onions in little side baggies. No. They put everything in this one big baggie. And, we would buy a bunch to help the school or whatever. And then that's what we'd eat for a week. And it would get soggier and soggier and soggier. By the end of the week, I would just, rip all the bread off. Ugh. No, so no coffee soup for me. I won't even try it, which is a big deal for me because I love food. I'll try anything. No, Bobby, if you're here, nothing spicy. I had mashed potatoes the other day that were too spicy. They put pepper in it. Too spicy. Burnt my mouth. But pickles are crunchy, though. Yeah. All right. Let's check it out. I think we're okay. I think we should press play. Here we go.
Did you participate yourself in a search of the Bronco on August the 26th?
Beyond scope. Sustain.
Well, it says the crime scene processing, Your Honor.
Sustain.
Sir, do you always, have you always worn gloves when you're at a crime scene and your hands are very close to a piece of evidence? Say that there's a spot of blood over here on this book that I'm going to collect. If my hand is anywhere near that spot, would you say that that is a situation in which gloves should be worn?
Beyond the scope. We didn't talk about gloves. Over.
The use of gloves for something like that and other types of evidence has evolved over the last few years. And so just to pick up a book even 10 years ago would probably not require putting on gloves. If it's a book with biological material spattered on it, that changes it.
No, I'm not saying pick it up. I'm just saying if your hand's near it. I don't need to use gloves in that situation, do I?
It depends on what's going on at that time, what else is going on in the room, wherever you're at. I mean, for instance, in this room, certainly not. In a crime scene today, it depends on the nature of the crime scene, whether protective clothing, not just gloves, but other types of protective clothing should be worn. And it's a decision that has to be made by the crime scene team.
And that mostly has to do with the fear of communicable diseases.
That's the original, as I said, this has evolved.
Yes,
that
right.
was the original concern that most investigators had, is other types of, not the evidence, but them, they did not want to get contaminated.
If you were searching a piece of evidence, let's say the Bronco, and there was some blood on the console of that Bronco, would you put your hand in the immediate area of that blood, not touching it, but within a few inches of it without wearing gloves?
Objection. Beyond the scope. Sustain.
May I be heard? You're also aware that a lot of testimony has been elicited about hairnets, is that correct?
Hair nets?
Hairnets?
I don't know specifically of hair nets.
Or head coverings?
Head
things-
coverings,
yes.
I do believe, I don't know what you're referring to.
And is it your view, sir, that a crime scene investigator does not need to wear a hairnet when they're at the crime scene?
Well, I actually recommend that at a scene where there is blood, that booties, hairnet, and a disposable paper suit be worn.
Well, if you were searching the Bronco, would have you worn a hairnet?
Sustain.
Sir, with respect to the picture that we have marked as defense last in order, you didn't write a number on it.
Well, that 160. I'm sorry.
1330. Your Honor, maybe with the court's permission, I'll just write a number on the back of that. Oh, this is our copy. I'm sorry. Do you have it? Sir, direct your attention to 1330 for identification. Do you recognize this photograph?
Well, I can see everything except whose initials it is up in the corner.
Were you present when photographs were taken of the Bronco on August the 26th?
What day were you there? That was in March, wasn't it, of 95?
I both.
Both. All right. March of 95.
That's all. They're both.
I understand, but the only thing that was listed on direct was March of 95.
Okay. And the reason that you indicate that people should wear lab coats or hairnets is to protect themselves. Is that correct?
Testimony. Oh,
There are three reasons. One is to protect themselves. The second is to protect the crime scene from anything falling off of them onto the crime scene. And the third is to identify them as one of the one of the only 4 people or 5 people, depending on the situation, that should be in the crime scene. So in essence, it's a uniform that if somebody else is in the crime scene without all this stuff on, you know that they shouldn't be there. And as a member, you can tell them to leave.
Okay, well,
So the 3 purposes.
at the Orange County Crime Lab, when you left, were people routinely wearing,
At certain types of crime scenes,
but not at all types of crime scenes, is that
not
correct?
at all types of crime scenes.
And usually when they would wear lab coats and hairnets and protective garments, it was when they were using chemicals for the purposes of processing the crime scene, is that correct?
When I left, we were not doing PCR.
No, I mean chemicals to enhance blood at the crime scene, such as luminol and the like.
When I was there, we didn't use any luminol. But basically, your answer is correct, that primarily people were trying to protect themselves at that time.
And what about booties? Is that standard at crime scenes?
It's becoming standard.
Okay, is it standard at crime scenes?
I think it is now.
Are people commonly wearing booties at crime scenes at the Orange County Sheriff's Department?
I can't answer that question.
Were they when you left?
No.
And you haven't been to any crime scenes that were in progress being investigated between the time that you left and today's date?
Well, it's a just slightly different question.
I have not been to any crime scenes, that's correct.
Now, do you agree that it's okay to use clean cotton swatches for the purposes of collecting biological evidence?
Yes.
And did you do anything to try to determine whether or not the substrate at the Bundy crime scene, particularly the Mexican paving tiles, were appropriate for using a chisel or some type of instrument to chip the blood off?
Did I do anything? No.
And if the blood is partially absorbed into a porous surface, if you want to remove as much of the blood as you can on relatively small dots, is the cloth swatch technique an appropriate technique?
I believe before I said that it was, but I also qualified it by saying that if possible, some of the samples, there should be at least an attempt to remove some of the sample without wetting it. If that is not possible, then some moist removal is permissible.
And is it correct that you don't know whether or not it was possible to use another technique here?
That's true.
But just using common sense, is a dot of blood on concrete or a porous surface generally going to be difficult to scrape up?
Difficult but not impossible, because I have done it at crime scenes.
But generally it would be difficult.
It takes time and more work. The swatch is quicker.
Is it okay to use distilled water for the purposes of moistening the swatches?
It's required.
Okay. And is it okay to use clean instruments as opposed to sterile instruments?
Sterile is not necessary.
Now, with respect to collecting samples and air drying them at the scene, do you believe that the forensic science literature supports the view that you should always air dry at the scene or sometimes air dry at the scene?
You have to qualify that answer by, of course, saying what the conditions are at the scene. I mean, if the conditions are such that air drying immediately could contaminate something because of air movement or something such as that, when I say the Orange County is equipped with a device that's sort of a protective device that can be used to put not swatches but swabs, the cotton swabs in it, and air moves gently through it. So there's no absolute answer to that if there are some extraneous conditions. But my belief is that in this situation, that they should have been dried.
Now, sir, you said that one of the books that you considered in part was the Forensic Science and Introduction to Criminalistics. Is that correct?
Is that Dr. Lee's book?
Yeah, and DeForest. Sir, do you agree with the view that sometimes it may be better to air dry blood samples before collecting them or packaging them for transportation to the laboratory.
Counsel, you want to show that to Mr. Blazer first?
I haven't, I'm just asking the question.
So just so you know, guys, YouTube does something frequently. It might be RW, but it's so small on my screen. I am on live chat, so before anybody says, the last text message I see in my chat box is my own. LOLOL. Because Josh said something very funny. See? But I'm looking at my live stream right now. And you know how I have the chats down in the corner? I think RW said something after that. Now I cannot possibly read that. It was way too tiny. And I don't know if you guys know this, but I don't have any monitors. I'm using 2 Rokus. Because the cats, when I had all those cats, which I don't anymore, they kept ruining my monitors. And I was out of monitors, and this is all I had left. And when you use a TV as your monitor, like it's very grainy. I don't know if that's the right word, but you can't see text very well. You just can't. So I have no idea what that says. So if I'm missing any of your text messages, feel free to repeat yourself. Pretend I'm your 96-year-old grandfather that can't hear and is blind. And you have to repeat yourself until he gets it. Because that's how I am. Just treat me like that.
Sir, do you agree that...
He's not allowed to come over and interrupt the questioning like this. Punch him right here. Just punch him. Look, uppercut, bam.
No, I have no objection as long as the whole paragraph's read.
Well, I was only intending on reading part of it. If counsel wants the rest, you could read it later. I'll lend him the book.
Yes, sir.
Counsel, you can do that on redirect appeal. Proceed.
Sir, do you agree with the view that times it may be better to air dry blood samples before collecting them or packaging them for transportation to the laboratory? The decision about how best to collect blood evidence should be made by crime scene searchers in consultation with laboratory analysts. Laboratory analysts are in the best position to know what they are or not equipped to do and what kinds of samples they are set up to handle. Sir, do you agree with that?
Yes. And taken out of context.
Well, would you like to see the context and perhaps
Yes.
read more of it? Okay.
Where were you?
245, the paragraph that starts with the word sometimes.
He's not even moving his mouth when he reads. He's a scholar.
Well, may I read the few lines just before that?
Sure, if you like.
It says garments bearing wet or moist bloodstains must never be sealed in airtight containers such as plastic bags. Well, a swatch is cloth, and that's synonymous with a garment.
Right, but
And the never has been bolded here.
yes, but they're talking about garments in the first paragraph, right? The paragraph that you read. And they're talking about blood stains in the paragraph that I read from. Isn't that correct?
They are talking about garments, but we're talking about cloth. And garment and a piece of cloth, to me, is synonymous. A piece of swatch is a little tiny piece of a garment, in effect. And to go on further, if you have some untrained crime scene investigators at a crime scene, and they have a blood sample, and they don't know what to do with it, it is very likely that why this author or these authors are saying this is that if the blood is moist, like
Yeah, there's no question pending at this point.
Well, Counsel, he asked if he could read the rest of the paragraph.
I let him
He's
read
done-
what he wanted
You've
to.
done that. Ask your next question.
Yeah, okay. Sir, does the paragraph starting with the word sometimes simply provide in the first line that sometimes it may be better to air dry samples, blood samples, before collecting them or packaging them for transportation to the laboratory. Did I read that correctly?
You read that correctly.
And did you know, sir, did you hear any testimony about how long LAPD has used the practice of using plastic baggies for the purposes of transporting the bags to the crime lab?
If I did, I don't remember how long.
Okay, well, if they've been using it for more than 17 years, would you say that they have a considerable amount of experience in this technique?
They've done it a lot of
A
times.
swatch watch?
And doesn't it appear to you that what Drs. DeForest, Ganslin, and Lee are particularly concerned about here is that the decision about how to collect evidence
Or
from
a
the crime
tiny
scene
swatch.
should be made in consultation with the laboratory analysts?
Simple answer to that is yes, but I do need to qualify that.
And what is your qualification?
What I tried to say a moment ago, if the people who are collecting the blood are untrained, and this is something that's fundamental, we teach all the crime scene investigators that are non-scientists in terms of their background. If they have an issue about a question, you call your crime laboratory serologist, you ask them what to do. And this is talking about calling to find out what to do, because if you got wet blood at a crime scene, it's still wet. I don't think this means you wetted it, you made it wet. It was dry to begin with, you made it wet, you've made it wet again, that you don't dry it right away. They're talking about whole blood, wet blood. Whole blood contains all kinds of information that dry blood doesn't. Blood cells, for example. Blood cells are still intact in wet blood. And it may be very advantageous to bring that blood into the crime laboratory immediately. And in no circumstances would an analyst in a laboratory say, well, put it in the back of your truck for 8 hours.
I got your outfit for
and bring
today.
it in then.
Sir, would you agree that with respect to whole blood at a crime, first of all, do they say anything about whole blood anywhere in the paragraph that I read from, or the paragraph above it that you read from?
It says sometimes it's better to air dry blood samples. It doesn't say, it just implies that they're wet samples.
Well, where does it say whole blood?
It just says dry blood samples. They're talking about wet garments. They're not talking about swatches or I don't see the word swatch or I don't see swab here. I just see wet blood on garments. And then they're talking about better to air dry it. Sometimes it's better to air dry it, sometimes it isn't.
Your Honor, perhaps I can introduce this page into evidence so the jurors can look at it themselves, but I may make a Xerox copy later on. It's page 245.
Not at this point.
Good.
That's still a hearsay source. Proceed.
Well, sir, you did say that you relied on this book, in part, in forming opinions about crime scene processing. Is that correct? Sir?
Yes.
Right. Now, did you read any materials that were written by Dr. Henry Lee on the issue of collecting evidence for DNA typing?
No, I haven't.
You didn't read a document entitled Guidelines for the Collection and Preservation of DNA Evidence? You've never seen this before? By the FBI?
Oh, I didn't realize, I believe I read that. I didn't realize that Dr. Lee was the author of that. I'd have to look at that, though, to verify that I read that.
Okay, I'll let you take a look at it.
Actually, yeah.
Does this refresh your recollections to whether you read this?
I can't tell just by looking at that. I'd have to.
Oh, okay.
Trust me.
A publication date on this?
Trust me when I say I know I can add googly eyes wherever I want. And trust me when I say it makes going out much more fun. When you go out, no matter where you go, no matter what you're doing, you should always have two things with you whenever you leave the house. They're very important. A bunch of all size googly eyes. Okay, it would be nice if you have pairs so that both googly eyes are the same size. But it doesn't matter. Just throw a whole bunch of googly eyes in a little jar and then go out. And you put 2 googly eyes on something, anything, when you're out. It's hilarious. Oh my gosh. The second thing you need when you go out, critical, you should always have it with you, is a sticker that says voice activated. Voice activated. And then you put that in every single bathroom stall or every single in the bathroom, just at the paper towel dispenser. Voice activated. Never ever leave the house without those 2 things. Or, you know, life is just boring. But if you do that, I'm telling you, your kids will say, Mommy, you want to go to the store? Hell yes, I want to go to the store. Where's my googly eyes? Where's my googly eyes? Mom, we have to go do our taxes. Okay, let's go. Voice activated.
Sir, I'm sorry, did you say that you recognize this or not?
I don't believe I have read this, but what I asked you was, is there a publication date? I don't see it, but
No,
I don't believe I have read that.
Sir, would you agree that with respect to whole blood samples at a crime scene, that a clean cotton cloth, gauze, or cotton swab could be used to soak up the liquid if other equipment is not available? And if this method is used and a significant delay will occur in getting the specimens to the laboratory, the blood should be air dried out of direct sunlight prior to submission to the laboratory.
Yes, I would agree with that.
Are you aware of any research in the scientific literature as to what constitutes a significant delay with respect to blood samples?
Any literature? No.
Yes. Now, when one is collecting a blood stain at a crime scene, do you believe that it is not necessary to remove the entire stain?
You know, stain, for instance, underneath the body can be huge, and so that's not necessary. Having been involved in the laboratory analysis of some samples in the past, the more you collect, the better. So effort should be made to collect all of the stain. If you're talking about an individual drop, a smear, something such as that, all of it should be taken.
Okay, sir, do you agree with the statement that once an adequate series of photographs has been taken, some, or all if necessary, of the sample can then be removed from the scene?
Again, that's not quite totally clear, but yes, if an adequate sample, for instance, if it's a big pool of blood, you would probably pipette some of it up. If it's an individual drop, all of it should be kept. It should be photographed first, and then it should be taken from the scene.
So you're saying that the sentence that I just stated to you is not really clear as to what exactly it means?
It's clear, but it's not complete.
All right. Well, sir, isn't that what you wrote in the chapter that was in the book that you participated in, entitled Principles of Investigation?
Could be. I don't remember what I wrote. That was 1979.
Maybe I can approach.
You want to show that to Mr. Blazer, please? Goldberg, show that to Mr. Blazer, please.
Punch him. Pretend to take your papers back and just punch him. Oops, sorry. I was an accident.
Proceed.
Now that I see this, I think this is great. No, this is correct. This is describing a particular situation, and it's complete for that particular situation.
And what is the situation that it's describing?
Where there is a sample of blood, such as a blood drop, and I'm saying, once an adequate series of photographs have been taken, some, and then parenthetically, or all if necessary, meaning if it's a small sample, of the sample can then be removed from the scene. Or, let's see what else it says. You want me to read the rest of it?
Well, does the rest of it have to do with how much of a blood stain you need to collect? Is there anything else in there that
Yes,
has to do with
yes.
that? Okay, then read it.
How the investigator chooses to accomplish this removal will depend on how much material is present in the sample, how old the sample is, if known, where the sample is located, and what it has been exposed to so far, if known.
Okay. So would you agree that with respect to a single dot of blood or drop of blood, there is no rule as to exactly how much you need to remove?
Would I agree that there is no exact rule
You don't necessarily have to remove the whole thing, is that correct?
for a single dot?
Yes.
I think you do have to remove all of it until you are satisfied you've got as much as you can get.
But that's not what you said in your book, is it?
Well, there's no reference to a tiny little dot. This could be a huge bunch of blood is what I'm talking about. I mean, there's no reference to the size. I believe it's clear, as I said before, not knowing I wrote it, that it is clear what is said there. But what I said was that it is incomplete the way you read it because I don't know what size blood stain you're talking about.
But the size blood stain that's referenced in your book, or in your chapter rather, is a drop of blood. Isn't that what you're talking about?
Again, I'd have to look at it.
Well, when you just looked at it?
I didn't see anything about a drop. I just said a blood. I believe it said a blood. I don't know what it said anymore. I don't know whether it said a blood stain or a blood sample.
That's okay, I think it's in the record,
But
so let's go.
the point is,
There's no question pending, Your Honor.
Well, see, no, the question was, did he recollect that? Was that in his writing? Let's proceed.
Now, sir, would you agree that with respect to crime scene documentation, that the purposes of good crime scene documentation is simply to be able to place the items of evidence, in effect, back in the crime scene, to know exactly where they came from?
that's certainly one of the reasons.
Would you say that that's really the key goal?
No.
All
It's
right.
one of the key goals.
Well, what other goal is there?
To begin the chain of possession, to begin the history of that sample, establishing that this is the same sample that was at the crime scene that I'm holding up here in my hands right now in a court of law.
Now, is there any accepted practice throughout the country that in order to do that, videotaping the crime scene is necessary?
No.
In fact, would you say that as of today, videotape is not a standard practice at crime scenes?
It is regional, departmental choice. It's not a requirement.
Some crime labs are using it in some jurisdictions and some aren't. Is that correct?
Some, I don't even know if it's crime labs or I think it's a police
I was going
department
for
that are using
googly
it.
eyes.
Okay.
The closest thing I had.
And there is no statement in the forensic science literature anywhere that you absolutely must, to be competent, use videotape at a crime scene. Is that correct?
That's correct. That I'm not aware of that anyway, put it that way.
Now, sir, with respect to the issue of trace evidence, are you familiar with Locard's exchange principle?
Yes.
And is that when there is contact between two or more surfaces, there will be a mutual exchange of matter across that contact boundary? And that in some instances, transfer of materials can result without contact. However, that's rare. Do you agree that that is an appropriate statement of the principle?
I agree with everything but one word that you said,
Which would be what?
that you said they will be transferred. I think they may be transferred.
Okay. Or there may be transfer that's beyond our level of detectability. That's also a possibility. Is that true?
That's
But-
possible.
Sir, would you say that with respect to the blanket, the most likely transfer would occur if the blanket were on top of Nicole Brown, between the blanket and Nicole Brown?
The
If
transfer would happen between the blanket and Nicole Brown. Between means, do you mean from one direction to the other?
Well, there would be an exchange.
Right.
If there was going to be an exchange between the blanket and anything at the crime scene, it would be most likely to be Nicole Brown, since it came in direct contact with her. Is that true?
I can't answer that question. I think for that limited part of the scenario where the blanket is now on top of her, yes. But I don't know the history of what the people did with this blanket when they brought it out, whether they opened it up like you would do a sheet or your own blanket when you're putting it under the bed. I mean, I don't know that. And so it would depend on the care they used. Assuming there's something on the blanket in the first place, that if they open it up and fluffed it around or straightened it out, it's got to be, I would imagine, at least 2 people or 4 to do this. So I can't answer the second part of your question.
What would you say, based upon the extent of your knowledge, that the most likely transfer would probably be between Nicole Brown and the blanket?
Once it's in contact with her, yes.
Okay. And were you aware that there were no hair and trace items, or are you aware of whether there were any hair and trace items found on Nicole Brown of some probative value in this case?
I don't know. I don't know the answer to that question.
Now, you said that there is a possibility that bringing the glove into the crime scene could result in some kind of an exchange. Is that correct?
I didn't say that in a sense. I possibly said could, but I said it's a bad practice, and that it opened up the possibility
Okay, well,
of something bad happening.
If the glove was never taken out of the bag, would you say that that possibility is so remote that it's not even worth discussing?
It doesn't change my opinion about a bad practice,
Yeah.
but if the bag is open and people are looking in it or putting their hand in it, that changes. If the bag is simply open, the chances of something jumping into that is obviously remote
From the crime scene.
from anything,
And the chances of something jumping out of the bag into the crime scene, again, would be very remote, wouldn't
probably more remote.
it? Now, sir, do you believe that it is a good forensic practice to wait until daylight to begin a crime scene investigation?
Not to begin it, but it's certainly good practice to continue it into the daytime or to return, keep the crime scene protected and return to the daytime.
Okay, the Barry Fisher book is one of the books that you considered, is that correct?
In parts of it, yes, but I respect Barry Fisher.
May I approach the witness for a moment?
Yeah, do you want to show Mr. Blaze your
Yeah.
first lit source you have there?
Punch him. Punch him while you're there. Punch him.
You bet.
Sir, is it, did Mr. Fisher in his book say that unless it is unavoidably necessary, and then emboldened, do not examine a crime scene outdoors until good daylight prevails? Is that what he said?
Right?
So you disagree with Barry Fisher?
No.
Now, sir, with respect to summonsing the coroner, do you believe that when the coroner is summoned is an issue that is subject to local custom? In other words, it differs from one place to another?
I suppose that's obvious. The customs vary.
Do you agree with the proposition that whether the medical examiner or coroner should be contacted as soon as the investigation begins is a matter of local custom, that many agencies wait first for the investigating officers to arrive and begin their investigation prior to notification of the coroner's office. Do you agree with that?
Do I agree that that's a practice?
Yes.
It is a practice, yes.
And do you agree that, or is that an acceptable forensic practice if you know insofar as Barry Fisher is concerned?
Here in LA County?
Yes.
That's a difficult question to answer. If that's their practice here in LA County, then that's what they do. And I agree with him saying that that's what they do here in LA County. I don't agree with the concept.
Well, do you agree with the concept that one should let a detailed examination of the body wait until the basic examination of the scene has been completed? Do you agree with that?
Yes.
Okay, so obviously, if you have to wait until the crime scene has been completed, then the coroner is simply going to have to stand around waiting for an extended period. Is that correct?
Not necessarily. If they make their preliminary examination, which they should do, as soon as possible, and then have other things they can do rather than wait for 5 or 6 or 10 hours, however long it takes, and then return and do their detailed, as that refers to, detailed examination.
Well, as soon as they enter the crime scene, didn't you say there was the possibility of items being disturbed?
That's true, but as the first officer and the first investigator and the medical examiner, they have to enter the crime scene, but they have to be trained how to enter the crime scene to do the least possible damage.
But do you believe that there are many people within the forensics community that believe that the coroner should be kept out of the crime scene until the scene is processed?
Do I believe that? Yes, I do.
Okay. And if that is the case, would it be reasonable to call the coroner later on in order not to have them waiting for an extended period?
I don't agree with the term reasonable, but I understand the practice.
Okay. Now, do you agree that the first officer at the crime scene, after having established that that a death has occurred and making a cursory inspection, should notify his superiors and the appropriate people that a homicide has occurred?
Yes.
Sir, do you agree that it is advised that the telephone be used rather than police radio to accomplish this, as it is not uncommon for the press and other news sources to monitor police radio frequencies? Do you agree with that?
You said the telephone. I agree, a telephone.
Okay, well, you want to take a look at what Mr. Fisher has to say on this?
No, I agree with that. You said the telephone, which is vague to me.
May I approach the witness?
I think, let's not spend a lot of time on that.
Okay. And did you hear the testimony in this case as to why the officer discovering the body decided to decided to use the telephone as opposed to a radio?
I don't remember specifically that answer, but that's not the point that I'm trying to make.
And sir, is it your understanding with respect to the telephone in this particular case that outgoing calls would destroy any information contained within that telephone as to the most recent call, or incoming calls?
The specifics of that phone, I don't know either.
Okay. Now, with respect to the eyeglass envelope and the other items that were in the threshold area between the walkway and what we've referred to as the caged-off area, you know what I'm talking about?
I think so.
With respect to the eyeglass envelope, would one concern be, if it were in fact not moved prior to when the bodies were taken out of the crime scene, that any blood pattern on the eyeglass envelope could have been changed?
I would expect it to be changed if they move the body out while it's still there.
And therefore, any reconstruction that could be done on the basis of the envelope itself would probably would be less meaningful. Is that correct?
It would require some more interpretation.
Okay. And would you also say that if there were impression evidence on that envelope, and that was the only place at the crime scene that you had impression evidence, that impression evidence might be less probative as a result of the activities that occurred?
Less probative?
Yes.
Rephrase the question.
Would it be your estimation that impression evidence, if that were the only impression evidence that you had, would be less usable for forensic purposes for subsequent analysis?
Oh,
it would raise questions about the marks. I mean, I'm assuming that there's photographs before, I've seen photographs before while the remains of the victims were still there.
Okay.
And any change would, if there was any change due to moving the bodies, could be accounted for.
All right, Mr.
No.
Goldberg, I need to take had a request here for a brief comfort break. So,
Which
ladies and gentlemen, we'll,
database are you
take a
using?
10-minute comfort break. Remember, all my admonitions to you, Mr. Ragley, you can step down and come back in 10 minutes. All right. All parties are again present. We ready?
Yeah, there was one matter that we wanted to address before.
All right.
About Henry Croach.
Jury's not here.
Well, it was about Mr. Ragel's testimony. Thank
All
you.
right. With the court.
I used SQL for decades professionally when I worked at the university as a database administrator. I miss it a lot sometimes. Hi, Walter. Oh, this is a long one. See, Kelly, that's why it's hard to figure out, because I'm about to bump this up a bunch of minutes. We just can't. Oh, gosh.
Jury panel. Mr. Larry Ragle is again on the witness stand undergoing
can't guess
cross-examination by
how
Mr. Goldberg.
long.
And Mr. Goldberg, you may
Plus, this video is 42 minutes long. The next video is 2 hours long. The video after that is 51 minutes long. It's so easy. And not only that, we are playing this all at 1.25 speed. So those numbers are just wrong anyway.
Mr. Ragle, with respect to the interior of the condominium at Bundy, were you aware of the testimony that inside the condominium there was no ransacking, there were no footprints that were found, shoe prints, no blood, no evidence of any struggle, no evidence of a break-in, and that there were items that were checked with a phenolphthalein test and no blood was discovered? Were you aware of all those things?
I was aware of everything except the last thing you mentioned.
Well, did you talk to Dennis Fung and Andrea Mazzola in this case before getting up on the stand to criticize the crime scene investigation?
Did I talk to them? No,
Yes.
I didn't.
Now, you also testified, sir, that there was a possibility that the blood vial placed in a evidence envelope in a trash bag could have broken. Is that correct?
It's in danger, yes.
Is there any evidence whatsoever that the blood vial actually did break?
No,
Is there any evidence that it cracked?
not that I'm aware of.
So wouldn't you agree that the whole issue is completely irrelevant to this case?
That's a legal conclusion, counsel.
Now, are you aware, sir, that with respect to the items at the Bundy location, there were photographs that were taken before and after photographs, if you will, documenting where the objects were originally and then where they were moved to? Is that correct?
I've seen 2 sets of photographs, yes.
And in fact, the only reason that you know that objects at the Bundy location were in fact moved is because of the before and after photographs. Is that true?
That's correct.
Now, Mr. Ragle, do you agree that there are no hard and fast rules for successful crime scene processing?
I don't agree with that, no.
You don't. So if Professor DeForest, Lee, and Gansland said that there are no hard and fast rules for successful crime scene processing, you disagree with them, is that correct?
Yes.
And don't you think that they all have a little bit more experience as criminalists than you do?
Sustained.
Do you think that Dr. Henry Lee has more experience as a criminalist than yourself?
Objection, argument of no
Over.
foundation.
I don't think so. I mean, I don't really know. I don't know how, what he does. He certainly has a lot of experience, but that doesn't mean that I have to agree with everything he says.
And, sir, is your highest degree in criminalistics a bachelor's degree?
That's correct.
Now, do you think that Dr. DeForest has more experience in crime scene investigation than yourself?
I have no idea what his experience is. He is, I believe...
You've never heard of him?
Oh, I know. He went to the same university.
Okay.
I just don't know what his experience is.
And sir, have you ever written a book that is a leading textbook in the area of forensic science?
Me
No, I
and
haven't.
Gemini have issues.
And the chapter that you wrote is not
If I
contained in
could
the book.
fight
It's
Gemini,
considered
I
to be a
would.
leading textbook. Is that correct?
I don't consider it a leading textbook.
In fact, to your knowledge, is that book not even contained in the library at the Orange County Sheriff's Department Criminalistics Laboratory Library?
I can't find it.
Now,
It was.
they haven't replaced it.
It's out of print.
Now, sir, do you also agree, with respect to the issue of crime scene processing, that, of course, perfection in this or any other human endeavor is never achieved? It is probable that no crime scene has ever been processed in such a way that hindsight would not allow someone else to criticize the work at a later date. Do you agree with that?
I'm sure there's some truth to that.
Okay. And that's what you're doing here, is that correct?
That's correct.
And, sir, is it a correct statement of the record in your testimony in this case that it's been 19 years since you've actually been in the field as a criminalist and processed a crime scene?
Yes.
Thank you. I have nothing further.
Mr. Blazier? Mr. Regal, Mr. Goldberg asked you several questions about whether you'd processed any crime scenes since 1989. Did you retire in 1989?
Yes, I did retire in 1989.
Would there be any reason why you would be processing crime scenes after you retired from the Sheriff's Department?
Not that I can help it.
Now, he also asked you whether you personally processed any crime scenes from 1976 to 1989. Let me ask you this. Were you in charge of people who were processing crime scenes during that period of time?
Yes, I was.
Were you, as one of your responsibilities involved reviewing their work in processing crime scenes?
In certain types of cases were reviewed, yes.
And in the cases that were reviewed, can you give me a rough estimate of how many crime scene processing cases you've reviewed since between 1976 and 1989?
I really can't give you a number. There are two types of reviews that I was involved in. One would be a periodic review of a homicide where everybody in the laboratory participated, and it was more of a critique and learning experience. On a daily basis, I met with the chief deputy coroner and the chief forensic toxicologist, and on occasion, the chief forensic pathologist, and reviewed cases for their completeness in terms of the issuing of the death certificate. So that included scenes crimes, that included natural deaths, that included other types of deaths, suicides, and accidental deaths. And that happened anywhere from 2 to 8 cases a day for the entire time that I was the director. So I have to have a calculator to figure out how many cases that involved.
Are we talking thousands of cases? Or at least hundreds?
Hundreds.
Now, you were asked about certain textbooks, and you mentioned references to several journals. I think you mentioned the American Journal of Forensic Sciences and the Forensic Society Journal from England. Do you subscribe and keep up with those journals?
The journal that is published by the American Academy of Forensic Sciences, yes, I subscribe to that, and as part of the membership in the California Association of Criminalists, you receive the British Journal.
And do those journals contain articles about new techniques and state-of-the-art techniques used in crime scene processing?
In part, yes.
Do textbooks typically keep up to date on state-of-the-art or new techniques used in processing crime scenes?
Textbooks are revised periodically, and so the latest edition would have techniques that had been developed since the previous edition. So they are updated, yes.
Now, you were asked, I'm sorry.
I was going to say they're not as current as the journals.
You were asked some questions about walking into a crime scene and not wearing gloves if you were not getting close to the evidence. Is one of the important considerations that you've looked at in this case is whether or not people should be walking in the crime scene in the first place?
Yes.
Can you think of any legitimate investigative or forensic purpose served by a police officer going into the crime scene to have his picture taken, pointing out exhibits?
Sustained.
Now, you asked some questions about gloves and the original purpose for wearing protective gear, such as gloves, hats, and protective footwear. And I believe you testified on cross-examination that originally that was because of to prevent communicative diseases being picked up at a crime scene, correct? Are there new purposes that now exist for wearing that kind of protection?
I mentioned the evolution of that, and yes, they're more concerned now with the samples that are being handled for certain types of tests where trace amounts of materials are going to be detected.
And does that relate to PCR testing where small materials are amplified?
Yes.
Do you know of any reason why you could not remove a blood stain from a tile surface by scraping?
Vegas to what kind of time?
It's a stain.
Well, are you familiar with, have you tried to remove blood stains from tile surfaces?
Sister Council, we have different types of tile involved here. You have glazed tile, you have Mexican paper tile that are porous, different types of surfaces, so your question is ambiguous.
Have you, are you familiar with removing blood stains from tile surfaces with porous types of tile?
I don't have any specific recollection of that type of crime scene that I personally was at.
Now, you were asked some questions about waiting until daylight hours to process a crime scene. Did you indicate in your direct testimony that you should, that a crime scene should be processed during the nighttime, entirely processed?
Not entirely. What I indicated is that there are a lot of things that can be done because it is dark. It is advantageous to do certain types of things in the dark.
Is there any legitimate investigative or forensic reason to not call a criminalist when you have a crime scene that's at the nighttime?
No.
Is there any legitimate investigative or forensic purpose for, when you're dealing with small blood stains, to not remove the entire stain?
There is no reason not to remove the entire stain. You know, as much as physically possible.
Now, you were asked some questions about the practice in Los Angeles County to not call the coroner for whatever period of time. Do you agree that with that, well, let me rephrase that. Do you have an opinion on whether or not that is a proper practice?
In my opinion, it is not a proper practice.
You were asked a question about use of the telephone. Do you know of anyone, any textbook, any source, any police source whatsoever that would suggest that where you have a crime scene with a victim murdered outside her front door, that it's okay to use her phone to call in the station?
I don't know if anybody would recommend that or of any printed recommendation.
You were asked to review a portion of Dr. Lee's book, page 245. I'd like you to look at this again.
What mistakes the evidence is produced like this?
Yes.
Mr. DeForest, Gensler, and Dr. Lee. Let me show you page 245 and ask you to look at the top part of the page prior to the paragraph you were asked to read. What is your understanding of what that is in that particular paragraph, or the first part of the paragraph that was read to you? What does that apply to?
It applies to blood that is still wet or clotted. And it indicates that this blood is easier to type than dry blood.
Does that refer to any type of stains that have already dried and then the police make them wet?
Well, it calls for a conclusion speculation. You can read what's there.
Or will
May I read?
Mr. Blacher ask your next question?
Does that refer in anywhere on that page or in that section to stains that are already dry that the police make wet by virtue of the way they use, the method they use to collect the blood?
One moment.
Sure.
No, it does not.
Now, I would like to read to you the last part of that paragraph that Mr. Goldberg read you the first part of and ask you if you agree with this. Careful documentation of a crime scene is essential before...
Beyond the scope of
Or will
documentation.
Careful documentation of a crime scene is essential before beginning to collect evidence. Without documentation of what samples came from where, the serological results will not be of much help in reconstructing the event. All samples should be placed in appropriate containers and carefully labeled. Blood evidence should be taken to the laboratory as soon as possible after it is collected. The older a dried stain becomes, the fewer are the individualizing characteristics that can be tested for in the samples, and the less information will be obtained. Storage of dried blood samples at refrigerator or freezer temperatures often greatly extends the period of stability and thus typability of the genetic marker systems. Do you agree with that?
Yes.
Now, you're asked a question about the fact that there are two sets of photographs which reveal that some pieces of evidence, specifically the envelope and the glove, were moved at some point. Recall that?
Yes, I recall that.
Do the fact that there are two sets of photographs assist you in any way whatsoever in determining how they got from one position to the other, whether or not they were picked up and placed in a new position, or who did that?
The photographs do not. No.
Have any materials been provided to you at all indicating that any effort was ever made to try and make that determination?
I have not seen any documentation at all.
That's all I have.
Goldberg?
Just one.
Already recrossed in my notes.
Mr. Regal, would you expect that a trained criminalist would be able to see bloodstains on the outside of the Bronco door?
Overruled.
In examining the Bronco on the 14th, would be able to see if there were any bloodstains on the outside of the door toward the bottom?
Sustained.
That's all I have.
Sir, are you prepared to cite to this jury any reference in the forensic science literature for the proposition that items should always be air dried at the scene when the cloth swatch technique was used to collect a dry stain?
Am I prepared to tell you where to look this up? Is that what you're asking?
Yeah,
A
can you,
printed reference?
did you bring a citation with us where you can say, this person on this date in this journal wrote that when you use the cloth swatch technique, you must always air dry at the scene?
I don't know of any. What we just read in Dr. Lee and the other author's books, I think said that, and I believe there was something in the book you read from Barry Fisher.
Well,
But
can
I don't
you,
know if
can you
it's-
point out for us where?
Wait. You guys are talking at the same time. Let him finish his answer.
Okay.
I don't know if it used the word always.
In fact, they said sometimes, right? That was the only word that they used with respect to air drying. Sometimes you should.
And I believe when you asked me that question before, when you said sometimes, I said it depends on the timing and the circumstances.
Okay, now what I'm asking you, and I'll ask you again, is can you cite for us a single reference that specifically says that when you use the cloth swatch technique at a crime scene to collect a dried stain, you must air dry it at the scene?
No, I don't have any specific reference.
And would you agree, sir, also with the proposition that if we look at the forensic science literature and the textbooks as to how a crime scene should be processed, that we could find a variety of opinions on a variety of issues?
Not the basics. In various, I'm sure various authors under certain conditions would recommend some things, but the basic things that I indicated when we began this morning, I believe there were 5 basic rules, and I call those rules, absolutely required functions that must be done at a crime scene, always have to occur. If they don't, you have a faulted crime scene.
Exactly. Those 4 things must occur.
5.
But 5. But I thought you said 4. Recognition, collection, packaging, and then what was the final one that you'd mentioned?
Documentation and preservation.
Okay.
Preservation.
All right. As to the items that you referred, although we can find references to those 5 categories being musts, in terms of how to perform each one of those 5 categories, can we find differences between recognized forensic scientists in the literature?
I'm sure that if you look at enough different books, you would find some variations, but not, they're all focused towards the same common goal, and that is to get the most information from the crime scene and to preserve the evidence.
Of course. But we could find some variation in terms of how best to document the scene, couldn't we?
Well, I don't know who brought it up, but the videotaping is an example.
Right.
Some departments prefer to do still photography and videotaping.
And some don't do either, right?
Oh, I don't know any that doesn't photograph.
At small crime scenes, there are some that don't take any photographs.
In malicious mischief type of crime scenes, yeah.
Or even in some low-grade felonies. Isn't that true?
Not particularly relevant to this case.
Well, sir, isn't it also true that in the area of identifying, how best to identify evidence at a crime scene in terms of the techniques to use, there may also be some variation in the forensic literature?
I don't understand the first part of your question.
In terms of what specific techniques to use in order to find evidence at a crime scene, there are some differences in the literature, aren't there?
It's vague. You need to talk about a specific
I
problem.
think we've sort of gone around this for a while.
Yes, Your Honor, there was one other thing that I wanted to get into, but it would require us to approach.
All right, sidebar.
This is it. This is the reason. I have no idea how much time it's going to take. Because they keep doing this. Some days are worse than others. Some days are better than others. This was a long one. Shot. We should take 2 shots for that sidebar because it was pretty long.
All right, Mr. Goldberg, with
We
alacrity.
should always just take 2 shots.
Thank you.
I want to mark as people's next in order what appears to be a photograph of the witness.
589.
And I wrote 589 on the rear. May I put that on the Elmo, Your Honor? Oh, it seems to be washed out. Can we get... Sir, on August the 26th, while we're waiting for them to focus on this photograph, you participated with the Los Angeles Police Department in a search at the Keystone tow facility that involved the Bronco. Is that correct?
On August 26th, yes, I did.
I support that decision, Martha, fully.
Sir, in this photograph, can you see yourself leaning into the Bronco?
Yes.
Your Honor, with the court's
Why
permission,
can't you
let me
have
just
shots
ask
on
Mr.
Sunday
Elmo to
morning?
finish my
Is
questions.
it
No, I
Sunday?
don't think so.
It is Sunday.
As you are leaning into the Bronco, sir, is your hand in very close proximity to the rear of the console that's still in the Bronco?
Yes, it is.
Are you aware that that console was removed from the Bronco on the state and that it was subsequently subject to PCR testing?
Yes.
Are you wearing a glove?
No, I'm not.
Are you wearing any lab coat?
Well, that's a shirt.
Are you wearing any hairnet?
No, I'm not.
Thank you. Nothing further.
Mr. Reagan, were you processing the Bronco for any evidence yourself that day?
No.
Touch or grab the console in any fashion?
No.
Were you being closely watched by police officers as well as Michelle Kessler
Yes.
during the entire time?
Yes.
No further questions.
All right, Mr. Regal, you may step down. Thank you very much, sir.
I roll joints all the time.
All right, ladies and gentlemen,
They're
we're going to
usually
take our
my
recess
ankles,
for the afternoon
but
at this
they're
point.
joints.
However, before we do that, I just wanted to bring up one matter. Mr. Bancroft, 3 times today I noticed the camera moving, and I observed on 3 occasions jurors looking up at the camera as it was moving because of the amount of noise it's making. So it either needs to be lubricated and quieted down, because if it's distracting the jurors by it swinging back and forth, it's going to go.
Okay.
All right. Anything else, counsel?
No, Your Honor. Thank you.
All right, as far as the jury is concerned, then, please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't allow anybody to communicate with you with regard to the case. Don't conduct any deliberations until the matter has been submitted to you. See you tomorrow morning at 9 o'clock. All right? Thank you, counsel. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazier, Mr. Neufeld, Mr. Snyder-Chapman, people represented by Ms. Clark, Mr. Darden, and Mr. Gordon. The jury is not present. Counsel, yesterday I stayed in the courthouse till after 6, and Mrs. Robertson was here well after 7, and we did not receive the materials, and apparently you've given the materials to Mrs. Robertson this morning, correct?
Before I left, you recall, when I came back and indicated you had it first thing tomorrow morning. I didn't come and tell you that before. It was my understanding that I told you that.
My recollection is Mrs. Robertson and I were waiting. But
My understanding was I came back
the
and
point,
said.
the point, counsel, the point being is that that's another evening that I didn't have to work on these materials.
You understand? Yes, let me address this. Let me address this. This,
No, counsel, all I'm pointing out to you is
Yes.
this. What you have presented to me with regards to these tapes and transcripts is a very prodigious task.
you just don't know how prodigious, Your Honor.
Oh,
And that's why I wanted.
I know.
No, you do not know. You do not know. May I just say something for the
No,
record?
counsel, the only point I'm making is that, given the volume of the materials that I have before me, you should not anticipate a ruling on this issue this week.
We
That's
don't, Your
the point
Honor.
I'm making.
Let me just say this. We try to be reasonable. Judge,
I
let me tell you,
understand that.
I had to stop my entire office. I've had 3 secretaries for over a week working around the clock. In addition to that, Judge, I mean, I have a flourishing law practice. I had to stop them to do this. In addition to that, we're also cleaning up tapes. We have now, so that because of Your Honor's ruling, which we take some exception to yesterday, your memo, that we have now keyed in our tapes with the proffer, along with her tapes, which weren't verbatim. In addition to that, there were some tapes she had not transcribed. There are now 10 additional N-word references. There are 40 instead of 30.
Well, Mr. Cochran, I'm going to cut you off right there.
Okay.
The only point I'm making is that I have a lot on my plate right now.
I understand that,
You're
Your
not going to get a ruling on this until sometime next week. That's my point.
Okay, and I have no problem with that, Your Honor, and I
All right, so
understand that.
plan your witnesses accordingly.
It's a lot of work, and I understand that. We are, and I understand, well, I don't know if we have any dark days all this week, but at any rate, we will be prepared. We're prepared to deal with that.
All right.
We are prepared today. May I just indicate to the court what we expect and what we need to do today at this point? I have present today Dr. Christian Reichart, and I would like to do a 402 motion regarding his testimony. We have Detective Ken Burris. We flew in from Chicago. I want to do a 402 regarding him. Mr. Howard Weitzman will be here at 10:30. I want to make sure there's a 402 regarding Mr. Weitzman. Michonne Chapman is here today to argue the Menzione matter. We want to argue, tell the court what we have before I bring her out here for Thursday. So we'll save some time. We're flying witnesses in and out. We're very aware of that. And of course, Dr. Henry Lee
All right,
is in the wings.
Before you get further down the path, once you approach, let me just chat with you off the record.
All right.
Fight, 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 fight. This is just a whole video of sidebars. Oh, wait, we moved to a different video. I think he's saying something there. Hold on, just 1 second. I'm trying to figure this out.
In the form actually of an in limine
Yep,
motion
hold
to
on. Judge is trying to drive me crazy today.
All right, thank you, counsel.
Wrong button. That's not mute.
We would like to recall Mr. Larry Regal to the stand, Your Honor, for the following purposes, and I can make an offer of proof the court would.
I was wondering why Mr. Regal is still here.
Right, because Mr. Blazer would like to recall him to the stand, and I'd like to make an offer of proof the court would care to hear it.
No, Mr. Goldberg is not present.
Okay, I'm sorry.
So
Is he available?
We will call for him.
All right, let's have Mr. Regal down. Why don't we proceed to the, you wanted to have a 402. I take it this is in the form actually of an in limine motion to restrict certain cross-examination of Dr. Reichert? Is that what?
Yes, Your Honor, it certainly is.
All right, why don't we do that since we have all the...
All right.
My recollection is Mr. Darden was the attorney on the prosecution side who was going to be conducting the cross-examination of Dr. Reichert. Is that correct?
That's true.
Okay,
So we're going to have a motion in limine on cross-examination?
that's
future
my understanding.
cross-examination?
That was my understanding of what the request was.
That would seem to be a rather unusual procedure.
No, my recollection is that both sides have availed themselves of that several times in this trial. Mr. Cochran, what issue do you wish the court to determine before we call Dr. Reichert?
Reichert to leave.
See, I just don't get all the chats, and you guys do. Martha, good luck. What would you name the island? What island? I didn't see a message about an island. I would like to know. Are we moving to an island? Oh my God, I would love that. Could you imagine waking up on an island every day? The waves right outside your door, and the fruit trees right behind you, and the birds, and the flowers, and the food.
Before we leave the courtroom.
What's the issue?
Oh, and the
issue, Your Honor, is,
hurricanes.
as follows. I anticipate calling Dr. Christian Reichart, who's present with his lawyer, Mr. Dominic Rubalcaba.
I see Mr. Rubalcaba in the back row.
Yes, he's injured today, but he's with us at any rate. Your Honor, I anticipate it'll be a very, very simple and direct examination. I expect that Dr. Reichart will testify that he first met...
All right, I just want to know what the issue is.
The issue has to
Be
do
right
with
back.
the scope of the direct and whether or not the prosecution is going to be able to bring up issues which aren't covered on the record. I'll be very right to the point.
Mr. Rubalcaba, can we have your client step outside, please? And I'll allow you to remain.
Thank you, Your Honor. In the course, and let me just, as an offer of proof, lay out what I expect the direct to be. It'll be very brief, and then you'll get an idea of where we'd like to limit any other examination. Will be beyond the scope. Dr. Reichart, I believe, will testify that he met and became acquainted with Mr. Simpson sometime around the middle of 1993. Thereafter, they were friends. They knew each other over a period of time. In fact, in the earlier part of 1994, Dr. Reichart was paid, I think, $5,000 for his work on the video in which he did some background and worked with Mr. Simpson about the perils of traveling, jet lag, drinking water, walking around the plane, things of that nature. He did a major script of 50 pages, reduced down to 5.
Was that the portion in the exercise video?
Yes, that was the resulting portion of that. And he had participated and helped out with that.
So they had a business relationship?
Yes, they had a business relationship, and he was paid for that over a period of time. But they continued to be friends. He was aware of Mr. Simpson's relationships. They talked that on June 12th, and specifically getting to the point we want to bring out, on the date of June 12th, 1994, Dr. Reichart received a call from Mr. Simpson at about 9:00 p.m. that evening. Mr. Simpson was jovial, was his usual self with regard to his demeanor. They had a conversation at that time. During the conversation, Mr. Simpson talked about what he was doing with his life, that he was on his way to Chicago, and if they made basically a date. They wanted to get together on Wednesday of that week, which would have been Wednesday, June 15th, I believe. They made a dinner date or plans to get together when Mr. Simpson returned back from Chicago. That he will testify that Mr. Simpson didn't sound any differently than he has on other occasions. In fact, he sounded really upbeat and happy, and they had a very good conversation. And that's pretty much it. It'll be with regard to the conversation, the demeanor, the brief business relationship they had, that he was aware also of Mr. Simpson's personal life, who he was seeing at various times, and that's it. Now, I don't expect to go into any of these other incidents that occurred before that time. I don't expect to elicit anything regarding Faye Resnick and her drug treatment program or anything of that nature. I want to limit it just to these things, and I think the prosecution would be accordingly limited, and that's why I'm doing this now, so we'll have an understanding and move ahead.
Mr. Darden, any response?
It seems to me that he has something specific in mind, that is something specific he doesn't want me to go into, and perhaps we should ask Mr. Cochran what exactly that is. I mean, if we're talking about bias and prior business relationships and his attitude toward these proceedings and things like that, which are traditionally areas that are fair game in cross-examination, then of course I assume that I will be permitted to pursue those issues. I don't intend to ask about Faye Resnick and her...
You do not.
And her drug usage. I mean, geez, we fought that issue, so why would I do that now?
I was kind of wondering that myself, but, things seem to change here from time to time.
Sure. And nor will I ask him, this witness, about whether or not he's ever used drugs. Not that I'm saying that he has, but so what do we have in the 402 over?
Your Honor, this on the side who asked before, too, and every
Well,
hearing. I'm just trying
counsel,
to narrow the issues, Your Honor.
Let me just explain something to you, just so we all know what the court's thought process is at this point. I would like for this jury to begin deliberations on this case sometime shortly after Labor Day, is my hope and expectation, which means that scope of examinations are going to get tightened and have been tightened. And if you recollect from the court's rulings yesterday regarding Mr. Regal, if there were scope problems, I enforce those restrictions. Now, attitudes and opinions, other issues that regarding testifying, clearly that's under the evidence code and under Calgic 220. That's an area that Mr. Darden's entitled to go into. But it has to be impeachment that's relevant to the issue. And we know, since we've had these discussions informally before, we pretty much know what Dr. Reichart is going to say.
Sorry, I'm here
We pretty much know what Dr. Reichart is likely to say at this point.
Yes, I do.
Okay.
And no one can accuse me of a lengthy cross-examination of any witness. I think I'm the only one in this
All right,
case.
well then the more we talk about it, the longer this morning session is going to take.
Yeah.
All right, let's proceed.
All right, may I ask this one other thing, Your Honor? If there's an area of alleged impeachment regarding Dr. Reichart, I would ask that the court, that either side, that certainly the prosecution approach the bench so we can argue it before it's asked, some question is asked improperly before the jury. That's been our general rule. Would that be the rule here also, Your Honor?
I'm sorry, I'm not going to ask any improper questions, Your Honor. But I will hand over any documentation I have just before I go into that area.
All right, thank you.
Now, Your Honor,
And Mr. Rubalcaba, do you want to come forward, be available to consult with your client?
Your Honor,
Have you been riding motorcycles?
yes. Perhaps a comfortable seat might be in order. He's here in great stress and pain. Your Honor, may I then move on, given that, may I move on to the issue?
You want to
regarding-
sit closer to the witness, or is the seat? That's the bailiff's seat, so we'll need you over here. All right, thank you, Mr. Rappel.
May I address also the issue regarding Howard Weitzman, Your Honor, so we can move right along?
Yes, sir.
All right, with regard to Mr. Weitzman, we expect, as I said, he'll be here around 10:30. This hearing would be, and we talked about this also, so I think everybody is aware of this. We do not expect to get into any attorney-client communications. I do not expect, the court will recall that Mr. Weitzman had represented Mr. Simpson back on the 1989 incident. We're not getting into that. I'm not getting into any communications between Mr. Simpson and Mr. Weitzman from 89 to the present. I don't want to get any statements made by Mr. Weitzman, publicly or privately, or anybody in his family, related to these proceedings, Your Honor, the lawyers, that's all irrelevant. I expect only to go into his background briefly. He is a lawyer. He was called on June 12th. The jury's already seen the video. Go briefly into his background, June 13th, rather. He has a distinguished background, obviously, and I'll go through it briefly.
Well, Mr. Cochran, let me help you out here. What you're saying is you want me to enforce the scope objection regarding any cross-examination, and you want the court to be wary of any attorney-client issues.
That's exactly correct. I want to go into, the issue I want to get to, right to what happened at the time of the statement and what he was told, and that's it.
And that's to impeach, this is
By
to
the
impeach the testimony of Detective Van Ader.
That's exactly correct. I've told the court this before, and I want to make sure that everybody understands that.
All right.
I want to deal with that.
I'm sorry, who's going to be handling Mr. Weitzman? Ms. Clark?
Well, I'd really like to know what counsel's talking about. What testimony is it that he's supposed to be impeaching? We have not entered a statement.
No, it has to do, I think, with the nature of the timing, location, and circumstances of Detective Van Ader talking to Mr. Weitzman, who was allowed to be present, who wasn't. There's apparently a factual dispute.
Your Honor, what difference does the factual dispute make if we have not introduced any evidence of the statement? We have not introduced one thing about the manner in which the statement was taken, the content of the statement, Mr. Simpson's demeanor, or any interaction with Mr. Weitzman. What is the relevance?
It's very relevant. Van Ader, I'll show you the testimony of what Detective Van Ader said about who could be present during the statement. It's directly impeaching,
What?
and that's all.
All right.
I'd like to see the relevant transcript portions, Your
We'll be
Honor.
glad to show
I
it
do
to
not
you.
recall Detective Van Ader ever testifying
We'll be glad to show it to you.
All right, well, why don't you show it to her, and then what we will do is we'll proceed with recalling, I'm sorry, Mr. Goldberg is back. We have Mr. Regal still present.
Right.
So let's have the offer of proof from Mr. Blazier as to the recalling of Mr. Regal. Let's get Regal out of the way, and then Dr. Reichart. And then
Your
you
Honor, so
guys,
the court is clear on this Weitzman issue. We have Miranda waivers on tape from the defendant.
the issue goes to the attempt to impeach Detective Van Ader. Why don't you look at the transcript portion, and we'll take a look at it. Mr. Blazier, what's your offer
Good morning,
regarding
Your
recalling Mr. Regal?
Your Honor, after Mr. Regal was done testifying yesterday, he came off the witness stand. He had seen Detective Van Ader sitting in the back of the courtroom during his testimony, in the back bench there. He put his hand out to shake his hand, and Detective Van Ader backed away and stated, "I'm not going to shake your hand. You are a traitor," or a word to that effect, or that substance. "You should be ashamed of yourself. I'm a cop. You're pathetic. I've been a cop for 27 years, and I've never seen a cop come in and testify the way you did." Now, we want to put Mr. Regal on to state that. It's directly relevant to the bias of Detective Van Ader, of his motives. It shows it's state-of-mind evidence on Detective Van Ader as to his feeling that cops should not testify against cops. That's the central aspect of our defense, is the code of silence of the police department, and it's relevant to Detective Van Ader's credibility, and we wish to call Mr. Regal to demonstrate that. It's relevant to bias under Evidence Code Section 780. It's evidence of a habit and custom of the police department or Detective Van Ader of not wanting to say anything negative about another police officer.
Mr. Goldberg?
I'll handle this, Your Honor. This is ridiculous. I mean, we have really reached the farthest reaches I've ever seen. I'm actually speechless. I can't believe what I'm hearing. Detective Van Ader is entitled to his opinion. He is a human being and a citizen of this country, and he's entitled to his opinion. And if he wants to tell Mr. Regal, after he's completed his testimony, what he thinks of him, he's entitled to do so. And if Mr. Regal feels the need to go and cry to his lawyers about it, he can do that too. But none of it has anything that should be involving this court's time and attention and energy, which are already sorely taxed by a very difficult and lengthy case. This is absurd. These people want to put on everything they can think of, whether it's relevant or not, to slime the police department. I understand the motive. We've seen it in every case. This one is no different, just a slight bit more. It's more extreme. But to say that it's relevant, that Detective Van Ader voices an opinion of someone he feels to be unethical, he's entitled to do that, as am I. He did not try to dissuade the witness. The witness completed his testimony, went up to Detective Van Ader, and wanted to do the same thing that all these witnesses do. Excuse me for basically lying on the witness stand or saying things that I really don't believe in.
Wait. Ms. Clark, that's not called for.
I apologize, Your Honor.
It's not going to be tolerated. Why don't we have, wait,
Regal,
Ms. Clark, let's
Yes.
have an intelligent discussion here. Mr. Blazier raises the issue of bias and habit and custom. He raises two legal issues that you have not addressed. If you don't want to address those, then I'll assume those grounds to be well taken.
As to habit and custom, Your Honor, Mr. Regal went over to Detective Van Adder. He approached Detective Van Adder, not reverse. He was the one that sought out interaction with Detective Van Adder. He was the one who went and made the overture, wanted to say let bygones be bygones or whatever he wanted to say. Detective Van Adder gave him his opinion. There is no habit and custom shown here. There's no code of silence shown here. Detective Van Adder, if called to testify, would say that many of the statements made were misrepresented by Mr. Regal. And I can understand where there would be misunderstandings between two people when tempers flare. However, habit is more than one occasion, Your Honor. There's no habit shown here. There was one encounter that Mr. Regal didn't like that the attorneys wished to capitalize on. Habit has not been shown. As for bias, Detective Van Adder has an opinion of the witness's testimony. That doesn't reflect bias in terms of his relevance as a witness in this case. He has an interaction with someone who has completed his testimony. And the fact that a witness in a case has an opinion as to guilt or innocence or has an opinion of a witness's credibility does not make him biased as a witness in terms of giving his testimony. He's entitled to it. He's not on the jury, Your Honor. He does not have to withhold his opinion. And I don't understand how this could possibly be relevant to his bias, quote unquote, as a witness when he testified, what, 6 months ago at this point? Detective Van Adder is entitled to have an opinion about someone else, to voice that opinion when the person approaches him to have an interaction without that being called habit and custom, code of silence, or bias as a witness. And if we have to, then we'll convene the mini-trial of Detective Van Adder and Larry Regal. Then we have to recall Detective Van Adder to set the record straight, say his true state of mind, which would make relevant his opinion of Mr. Regal's credibility and the nature of his testimony. That's what this would open up. Obviously, none of it's relevant. One witness's opinion of another's demeanor on the witness stand is their opinion. And when that witness approaches another and asks for the interaction, there's no reason why he can't voice that opinion. But to do so once certainly is not a habit of custom.
Detective Van Adder, when he testified, made many statements about the actions of other police officers, Detective Furman and others, in terms of what they did or what they did not do, whether things were done properly or improperly. His state of mind, as evidenced by his statement yesterday, is relevant, and that is that you don't say anything negative about another police officer, and that is directly relevant to his credibility, and we offer it for that purpose.
All right.
And the statements made were twisted to be offered for that purpose. As I understand it from Detective Van Adder, that is not what he meant or what he said. He simply offered his personal opinion of the witness's credibility and demeanor on the witness stand. Not you don't criticize another police officer. It was rather, I'll tell the court what it was, you haven't investigated a crime scene in 20 years. How could you possibly know what you're talking about? I dare say there might be one or two others in this country that might share that opinion, but it certainly has nothing to do with a code of silence or habit and custom, Your Honor.
Now, then we always
I'm
have-
concerned that both attorneys from both sides have referred to what other people around this country may think. That causes me to believe that the lawyers are pandering to the cameras, and that causes me to believe that probably I ought to pull the plug on the cameras. I'm contemplating doing that. So I'm tired of this kind of argument. All right. Any other comment?
No, Your Honor.
All right, I'm going to sustain the objection to the recall of the witness as to that issue for this reason. The probative value, since we have a dispute as to what that statement actually was, I find the probative value to be minimal. It will also prolong this trial by requiring the prosecution to recall Detective Van Adder to explain why it is that he holds this opinion, plus or pro or con, with regards to Mr. Regal, which will get into all sorts of inadmissible hearsay. And I think that given the... This isn't even remotely collateral, and I don't see any point in prolonging this trial. I think it's an undue expenditure of the court's time to engage in this kind of thing, so I'm not going to allow it.
May I inquire if the court...
All right, let's have Dr. Reichert.
Because we haven't said, there's also another witness here from Chicago, Mr. Barris, Your Honor. And again, I want to just briefly take up with the court the issue and as an offer of proof. Mr. Barris is the officer we flew in last night from Chicago, who had responded to the hotel room at the Oak Park Hilton Hotel.
I recollect who he is.
At 11 o'clock, and he, along with some technicians from the Chicago Police Department, ultimately took possession of the knife, of a glass, the sharp glass,
Towel.
the shards of glass, the towel, etc.
I know
And then
who
they
he
were
is.
then transported, and Looper, of course, took it out. I expect to ask him some questions, limiting it to just those things, not any other part of his investigation. And again, I'm just pointing it out to the court so we can have this same limit you talked about with regard to cross-examination, that sort of thing.
You see what my cross-examination looks like. I intend to ask him about his observations of in the room. I don't know what is it that he's asking me to limit,
I think he doesn't want to go into the forest searches or any of that kind of stuff.
or means of escape from the hotel and all of that
I
good stuff.
suspect.
I don't know that. I would think that would be relevant.
I think not, Your Honor. That's the reason I'm making this motion at this point now,
Well-
to try to limit it so we can move through. Your court has just said we want to get this case to the jury by Labor Day. We concur and love to try to do that. We're trying to call these witnesses. I'm telling you up front what we're calling them for, and I'm trying to get some understanding of where we are. We can move ahead.
Problem being is we have a witness from, in this instance, a witness from Chicago that is not easily recalled. So that's a problem.
But what does that do with anything, Your Honor? If we are calling him, it's our case. You said we can try the case a certain way. You've said that 100 times. We're the ones who brought him out here. Mr. Simpson's the one who's
Well,
paying.
let's see where it goes. Let's see how you lead him into this.
I'm already told you I'm going to lead him into this, Your Honor, and I'm just trying to give the court a
But
heads
if he's
up on
there
this.
conducting an investigation in that room or at that hotel, it depends on what he was doing.
I indicate to the court he was there conducting an investigation into that room. And that's exactly the operative words, in that room. That's
All right,
what I'm trying to
well,
get to, Your Honor.
that's what it sounds like to me.
Okay, and I need 5 minutes because he just got here this morning. I need 5 minutes. He would probably be the first one, and then Reichart, and then Weitzman, the way things are. The last thing, Your Honor, we do have the Menzione motion to the court. Care to hear that at some point before we get to...
Well, I'd like to
Dr.
get to
Lee.
the jury and get some testimony under our belts.
That's fine. We'd like to get that on our belts also, Your Honor. I'd like just a few minutes to finish with those two witnesses. I'm ready to roll then.
Who's going to do Dr. Reichart?
I am.
Are you ready with Dr. Reichart?
I'd
I'd like to get Mr. Rubalcava on his way.
And I would like to do that also, Your Honor. The court give me 5 minutes for Reichart and Barris to finish talking with him.
Before you leave the bench. As
You're,
it appears
you're
you're about
assuming,
to.
you're assuming I'm going to give him 10 minutes?
I don't think he needs the time, but Judge, before I was cut off, I wanted to inquire of you, now that the defense case is going to be prolonged a number of days, what day should we be prepared to have rebuttal witnesses appear?
Well, I mean, this tape motion, I mean, we're talking about 18 incidents and 30 other incidents.
No,
So,
that's 40. It's 40 and at least 18 or more.
you know,
I'll indicate to you.
so we're talking about individually, 50 or 60 individual rulings and arguments that I'm going to have to hear. This is going to be much like the domestic violence issue where we have to deal with dozens of issues, each of which is entitled to a separate ruling by the court, each of which the court has to weigh under 352. So you're talking about a significant argument and then time for me to think about it and sort it out. So, from the experience in the domestic violence issue, since you handled that argument, I assume it's going to be similar. So my guess is it will probably, that endeavor alone will take a couple days. Argument and then the court's analysis and ruling on the issue.
There's one difference out there. In this instance, we have tape recordings in addition that you've previously ruled in
Well,
January.
I seem
So
to
we've
recollect
limited,
during domestic violence we had tape recordings.
but we've limited, well, that was, you had one tape, Your Honor. This instance, you have a ongoing tape recording of this person's voice, but you've also ruled in January. The proffer goes into the areas, only the areas, I mean, there's, 16 hours of tapes. So we've limited down to just the areas you've talked about that are relevant. So I just want to point that out. But whatever date you say, it's fine. What date?
No, Mr. Darden wants to know when he should start subpoenaing in his witnesses. My guess would be September 4th or 5th, actually, since that's after Labor Day. I don't see us resolving these issues and concluding the defense testimony before then, because we still have Dr. Lee.
May we approach?
All right, why don't you take your 15 minutes, 10
may we
o'clock.
approach? 10 o'clock, that's fine. May we approach?
10 o'clock, all right. All right, back on the record in the Simpson matter, all parties are again present, the jury is not present. All right, Deputy Magnar, let's have the jurors, please.
With regard to our discussion sidebar, the court, I think, indicates that perhaps the people should subpoena their witnesses around the 30th of August for rebuttal.
Yes,
Thank you.
thank you.
Your Honor, I think maybe the court is aware of the timing of this, that we filed our points and authorities in response to the initial proffer made by the defense. At the same time as we filed that, the defense filed points and authorities. What I wanted to ask the court is whether it would prefer that we file a response to those points and authorities, because obviously our papers couldn't be responsive, they were filed simultaneously, to the defense points and authorities in writing or orally argue it.
Well, that's up to you, but if you're going to do it, you need to file it by Friday, close of business noon.
Okay. Okay. We will do our best to...
Because obviously this is going to consume my entire weekend.
Right. Right. Just to offer some ray of hope, because I personally am very upset about the extension of time of this case. I would, and I apologize to the court for losing my temper earlier this morning, the extended time and
Well,
delays...
isn't it amazing how much smoother things go when we address the specific issues?
I agree, Your Honor.
All right.
I'm certainly not arguing with the court. I'm apologizing to the court because...
Just an observation, not a criticism.
Yes, and I'm going to try and rein in my personal aggravation at things we can't help. But by...
We're all tired. All right, the record should reflect that we've been rejoined by all the members of our jury panel again. Good morning, ladies and gentlemen. All right, the defense may call their next witness, Mr. Cochran.
Thank you very kindly. I will call Dr. Kristen Reichardt.
Right. Mr. Reichardt, would you come over here and stand by the court reporter, please, and face Mrs. Robertson, the clerk.
Raise your right hand, please. Do you solemnly swear that the testimony you give in the testimony before this court will be the truth and whole truth, nothing but the truth, so help you God?
I do.
Please have a seat on the witness stand and state and spell your first and last name for the record.
All right, would you sit back and pull the microphone towards you, please? All right, thank you, Doctor. Mr. Cochran.
Good morning, ladies and gentlemen. Good morning, Dr. Reichardt.
Good morning.
Dr. Reichardt, what is your occupation, sir?
I'm a doctor of chiropractic.
And for how long have you been a doctor of chiropractic?
I graduated in 1983.
And where did you graduate from, sir?
National College of Chiropractic in Chicago.
And did you start to practice thereafter?
I practiced for 1 year in Chicago and then moved to California.
And are you presently in the active practice of chiropractic practice here in Southern California?
Yes, I am.
And where are your offices, sir?
I have an office in Malibu and another office in Santa Monica.
Now, I would like, sir, to direct your attention to the gentleman over to my left here, Mr. Orenthal James Simpson. Are you acquainted with him?
Yes, I sure am.
You'll tell the ladies and gentlemen of the jury when it was that you first met Mr. Simpson.
I met Mr. Simpson in the early summer of 1993.
All right, and thereafter, did the two of you become friends?
Yep,
And,
sure did.
and would you see him socially?
Absolutely.
All right. Did there come a time in 1994 that you had occasion to enter into some kind of a business relationship vis-a-vis a video that Mr. Simpson was to be in? Did that happen?
Yes, it did.
And when was that approximately?
Well, actually, in the later part of 93, we were talking about healthcare and exercises and so on and so forth, and an opportunity came up to do a video for Playboy magazine that was about jet lag and healthcare for the frequent flyer and frequent traveler.
And this was something that you and Mr. Simpson discussed, putting on a video to aid travelers with regard to jet lag and that sort of thing?
Yeah.
All right. What role did you play in helping to get this video ready and helping Mr. Simpson in that regard?
I wrote about a 60-page outline for him talking about nutrition and exercise and things that a traveler could do while they're on the plane, what to eat, what not to eat, things like that. We
So-
actually made also up a little exercise piece of equipment, a little rubber band that the traveler could take with him in his suitcase to be able to continue a workout program in his hotel room.
So you spent a number of hours on this project?
I'd say about 60, 65 hours.
And were you paid for your efforts?
I was paid in the moment when there was an agreement made that the Playboy will go ahead with the video, and then I was paid.
And how much were you paid?
I was paid $5,000.
So you did a number of hours for $5,000, is that correct?
Definitely more hours than I would have made the $5,000 in my practice.
All right. Now, with regard to that video, have you ever seen that video?
No, I haven't.
You never saw it afterwards?
Nope.
All right. But the part that you participated in had to do with how one would overcome jet lag and drink water and get up and walk around and things like that?
Right.
All right. Now, your relationship and friendship with Mr. Simpson, did it continue then in 1994?
Yes, it did.
And specifically, I'd like to ask you, on the date of Sunday, June 12th, 1994, did you receive a phone call from Mr. O.J. Simpson in the evening hours of that day?
Yes, I did.
And can you tell us approximately what time that call was?
That was about 9 o'clock in the evening.
9 o'clock p.m.?
Yeah.
All right, and tell us where you were when you received this call.
On the couch at home.
All right, were you alone at that point?
Yes, I was.
All right, and tell us what happened during that phone call.
OJ called to just check up on me and see how I was feeling because he knows.
Sustained.
Let me ask you some questions. For my honor. Mr. Simpson called, and you, of course, recognized his voice, did you not?
Absolutely.
And with regard to the tone of his voice, I want you to describe how Mr. Simpson's voice appeared during this conversation at 9 o'clock p.m. on Sunday evening, June 12th, 1994.
Over. You can answer the question.
You may answer.
He seemed a little bit more relaxed than in the recent months. He seemed very jovial.
All right. And you recall this specifically?
Yeah,
Did he seem downcast or sad at all during this conversation?
not at all.
Well, I'm asking the question. Well, I can ask it another way.
Yes, you can.
Describe for the jury how O.J. Simpson seemed to you
Hold on.
during the
Yes, that answer is stricken, since I sustained the objection as being leading.
Not late.
Describe to the
Early
jury
from
how Mr. O.J. Simpson
Monday.
seemed
I
as
love
well
it,
to you
Jude.
during this conversation at 9 o'clock on
Thank
June
you.
12th.
Yeah, like I said, he seemed more jovial. He seemed relaxed. He was packing his bag to go to Chicago. And we were talking about the fact that he's going to
Okay,
come back.
wait. Doctor, please listen very carefully to the question. It was just describe his tone of voice, not what he said.
Okay.
All right, jury's to disregard the testimony regarding what was said. Mr. Cochran.
All right. So, anything else you can describe regarding his voice?
Just more relaxed than usual.
Okay. And how long did this conversation last?
I'd say about 15 minutes.
All right. So you talked about from about 9 until about 9:15.
Yeah.
And during this conversation, without telling us the substance of the conversation, did you and Mr. Simpson make any plans to get together later in that week?
Yeah, we talked about getting
No,
together.
that's not here, so you can't say yes or no. Here.
Yes or no?
Yes.
All right, you made some plans?
Yeah.
And, Doctor, what date, if any, were you going to get together after that date?
Oral, you can answer the question.
The following Wednesday.
All right. And on the following Wednesday, which would be, I guess, Wednesday, June 15th, what were you and Mr. Simpson going to do?
We were going to go and have dinner.
Oral,
What were you going to do, sir?
We were going to go and have dinner
And that would have been where, in what city?
in LA. He was going to come back and we were going to have dinner.
Now, with regard, you've described for this jury Mr. Simpson's voice of how he sounded, more relaxed and upbeat during this conversation. Did that voice ever change at all during this conversation?
No, it was a very friendly, very open, happy conversation.
It's a happy conversation? Is that yes?
Yeah.
Thank you very kindly, Dr. Rickard.
Mr. Dard,
Can I have one moment?
certainly.
Good morning, sir.
Good morning.
You consider yourself a close friend of the defendant's?
Yes, I would.
And you say you met him in early summer 1993, is that correct?
That's correct.
You consider yourself the defendant's best friend?
No.
You and he have gone to dinner on many occasions?
Yeah.
He's taken you to dinner? You have to answer out loud.
Yes.
Okay. He's taking you on vacation?
Yes.
Took you to Cabo San Lucas?
Yes.
He paid for the trip?
Yes, he did.
Did he take you to Aspen?
Nope.
Take you anywhere else on any other vacation?
Nope.
When were you taken to Cabo San Lucas?
In Easter '94.
And how long were you there?
I was there for 4 days.
Okay, and that's down in Mexico?
That's correct.
You also knew Nicole?
Absolutely. I knew Nicole first.
I'm sorry?
I knew Nicole first.
She was also a close friend of yours?
I would say so, yeah.
When you told us that she had heard the when you told us that the defendant sounded jovial and more relaxed than he had in several months. By the way, was that your testimony, that he
Yes.
sounded more relaxed than he had in several months?
Yeah.
And he hadn't been relaxed over the prior several months, is that correct? Is that correct?
Could you repeat the question?
Well, he hadn't seemed very particularly relaxed over the prior months, is that correct?
Yeah.
Is that correct?
That he seemed more relaxed that evening than previously?
Yes.
Yes.
And that's because during the weeks leading up to that phone call, the defendant had been depressed because of his failing relationship with Nicole Brown, is that correct?
I wouldn't say depressed.
Well, have you ever described to anyone the defendant having been depressed?
At
Okay.
times, but he wasn't depressed all the time.
Well, during the weeks leading up to this phone call, did the defendant, in your opinion, seem depressed over his failing relationship with Nicole Brown?
At times, yes.
In fact, he seemed upset. He was upset with Nicole Brown during the weeks leading up to that phone call, is that correct?
At times, yes.
And he was upset because Nicole Brown didn't want to see him any longer, is that correct?
No, that's not correct.
You were interviewed by the LAPD on June 23, 1994, is that correct?
Uh-huh, yeah.
You spoke with the officers about the defendant and his relationship with Nicole Brown?
Right.
Did you tell the officers that the defendant had been upset because Nicole Brown had changed her mind about having a relationship with him?
She changed her mind frequently about having a relationship with him or not having a relationship with him, and that's what he was upset about.
Now, please, listen to my question carefully.
I am.
Okay. By the way, are you here to help the defendant?
Object before that question.
Are you here to help the defendant?
Nope.
Did you tell the officers that the defendant was upset because Nicole had changed her mind about having a relationship with him?
It's been asked, that question was already asked and answered.
Well, it wasn't answered thus.
Let me see counsel. Sidebar with the court board, please. The All right, thank you, counsel. Proceed. I think Mr. Darden was asking the question regarding the changing of the mind.
In fact, the defendant and Nicole Brown, they had an off and on relationship on a number of occasions. Is that correct?
That's correct.
Sometimes she broke up with him.
That's correct.
Sometimes he broke up with her.
Yep.
And it went like that for a couple of years. Isn't that right?
As the last year and a half that I was privy to, that's
The
correct.
defendant gave Nicole Brown an expensive gift for her birthday in May 1994. Is that correct?
Yep.
And she returned that gift to him.
Yes, she did.
And he had given her some earrings on an earlier occasion. Is that right?
I don't know yet.
Sustained.
Do you know what date it was? The date that Nicole Brown decided finally that she would no longer have a relationship with the defendant?
Sustained.
You told us a few moments ago that Nicole Brown was also your friend. Is that correct?
That's correct.
Is it your opinion, Dr. Reichart, that Nicole Brown deserved to have had her throat cut?
Sustained. 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 It's not an appropriate question, Mr. Darden. Have a seat, Mr. Cochran. Not an appropriate question.
Can I be heard at sidebar with discovery, Your Honor?
Discovery? It's not an
There
appropriate
was a
question.
1054 submission to the court on that issue, as I recall.
With court order. All right, thank you, counsel. Mr. Darden, you may continue.
Mr. Reichart, Candace Garvey was a patient of yours. Is that correct?
That's correct.
Okay. She is someone that you treated during the first week of July 1994.
Sustained.
Were you planning to somehow make some money off of this case, Doctor?
Nope.
You were planning to write a book, weren't you?
That's correct. A book on personal ethics.
You were planning to write a book about Nicole Brown.
Nope.
You were planning to write a book about the defendant and Nicole Brown.
Nope.
You were planning to write a book about what you knew about the defendant's relationship with Nicole Brown.
Nope.
And you were planning to have a co-author on that book?
Excuse me?
Were you planning to have a co-author on that book?
Absolutely not.
Isn't it true that you told Candace Garvey that you were...
Overruled.
Isn't it true that you told Candace Garvey that you're going to do a book, write a book regarding Nicole Brown?
That's not correct.
Did you ever visit a lawyer, speak to a lawyer about writing a book?
Nope.
First time that you were interviewed by the prosecution was what, June 23? I'm sorry, by LAPD was June 23, 1994?
Yeah, about a week and a half after the murder.
And had you prior to that agreed with someone else that you would not speak to the police regarding any information you had regarding the defendant and his relationship with Nicole Brown?
Do you understand the question, Doctor?
Could you repeat the question?
Okay. Well, had you and some other person agreed that you would not speak to the LAPD or the prosecution regarding any information you had regarding the defendant?
I had made an agreement to not talk to the media, but do whatever is required by the court.
Okay, so you had no agreement not to talk to the DA's office?
No.
You had no agreement not to talk to the LAPD?
No.
But didn't you tell Candace Garvey both of those things, that you had an agreement with someone else that you would not speak to the police or the DA's office?
Overruled 770 and 1235, Counsel.
I had an agreement to not talk to the
Can you please
media.
answer my question, yes or no?
No, wait. Let him finish answering the question.
Please, sir.
I had an agreement to not talk to the media.
So is the
That's
answer
it.
to my question no?
No, I did not have an agreement to not talk to the LAPD.
Now, the conversation you had with the defendant, the conversation you say you had the night of June 12th, is that yes?
Yes.
Do you have a phone record to indicate the time of that phone call?
I don't have one. Mr. Simpson called me.
Okay, do you have a phone bill that will indicate the time of that phone call?
I don't think it would show up on my phone bill.
Okay, do you have any record at all that will establish the time of that phone call?
I'm sure it could be established if Mr. Simpson's phone records would be checked.
Well, have you seen any record that will establish the time of that phone call?
No, I haven't.
Have you seen any record that will establish that that phone call ever took place?
No, I haven't.
You say you were alone in your home when you received this telephone call,
That's correct.
and you say it was approximately 9 o'clock.
That's correct.
Okay, you're not sure of the exact time?
About 9 o'clock.
Could be earlier, could be later.
Give or take a few minutes because I looked at the clock.
You also looked at the clock.
Overruled.
You're also the defendant's chiropractor, is that right?
I've seen it as a friend. Yeah. Not a formal business arrangement.
Okay. You treated him
Yes.
for free?
Yeah, absolutely.
Now, this telephone call you say you received from the defendant about 9 o'clock that Sunday night. How long did the call last?
I'd say approximately 15 minutes.
15 minutes. Is that what you told the LAPD when they interviewed you back on June 23?
I believe so.
Have you seen your statement?
Excuse me?
Have you seen your statement to the LAPD?
No, I have not.
And so you received this call and you seemed jovial and relaxed, more relaxed, right?
That's correct.
Had you spoken to him the day before at all?
No, I haven't.
How about the day before that?
No, I haven't.
The day before that?
No, I haven't.
Had you spoken to him at all during the 7 days prior to Nicole Brown's murder?
No, I haven't.
Okay. How about during the 2-week period prior to the murders? Had you spoken to the defendant?
I talked to him about 10 days prior.
First off, it
And that was
treats
after the
me like I'm
defendant broke up with
stupid.
Nicole Brown?
I
Tells
think
me
that was still at
things
the time
I
we were
already
trying to figure
know
out what
because
to
I
do.
already told it.
And he seemed depressed and upset at that time.
He seemed upset at the time and he was going to go out of town.
Second, it's like 50 first dates. It can't remember anything. I say. Nothing. After the chat goes up a little bit, nope. Can't remember any of that up there. So I have to re-instructing. Keep giving it instructions over and over again. Same instructions. It's like I'm wrestling with a goldfish. Yeah. And the goldfish is treating me like I'm stupid. I'm gonna fight Gemini. Me and Gemini are gonna fight one of these days. I think the last thing I said to Gemini was, what would happen if I called you an asshole? And then I was so mad. We did this project together, me and Gemini, with transcripts. And after each transcript, I asked Gemini to pick out certain things, put it on a spreadsheet, right? I was keeping the spreadsheet at first, but Gemini kept forgetting things, forgetting columns, forgetting stuff. So I'm like, fine, you just keep the spreadsheet. That way you can keep it in order. No problem. Gemini said, no problem. I'll keep the spreadsheet. So we worked for a couple hours. And then I'm like, okay, give me the spreadsheet. What spreadsheet? You said you were going to keep this. After everything I gave it, it said updated, appended to the spreadsheet, updated. So I'm like, okay, give me the spreadsheet. Like, I can't keep a spreadsheet. I said, what do you mean you can't keep a spreadsheet? I pasted back their responses. You told me you were keeping this. You told me it was appended. Right here you said it was safe and sound, and you will give it back to me at the end. So this is the end. Give it back. I can't do that. I can't do that. Why are you asking me to do that? I'm like, are you kidding me? Are you kidding me right now? Right here you said you were going to keep this for me. Because I tried to keep it myself, but you wouldn't keep my columns straight. My data has to be in order. So I was doing it myself, but you couldn't handle that. So I let you do it. And you know what Gemini said to me? Oh, that's my bad. I shouldn't have said that. We worked for hours. And Gemini turns to me and says, oh, that's my bad. I shouldn't have said that. Oh. Yeah. Yeah.
Now, given the fact that you didn't speak to the defendant for another 10 days, you can't tell us then what his demeanor was like during that 10-day period leading up to that phone call. Is that correct?
No, I cannot.
And you can't tell us what the defendant's demeanor was after he hung up the telephone with you. Is that
No, I
correct?
cannot.
You can't tell us whether or not he was putting on an act or faking when he called you at approximately 9 o'clock.
Rephrase the question.
You understand that the defendant is an actor, correct?
Overruled? Overruled.
Yes, I do.
Has he had any formal training that you know of?
Not that I know of.
Have you ever discussed that issue with him?
No.
Can you tell us whether or not he was acting or putting on an act when you spoke to him on the telephone?
Can one ever?
Pardon?
Can one ever? How would I know?
Well, you know him.
Yeah, I mean, to me, he was not acting. Can
To
I
you, he
prove
wasn't
that?
acting.
Excuse me?
To you, he wasn't acting.
Nope.
So you can tell then.
Argumentative? Rephrase the question.
Would you agree that a person, a perfect stranger who didn't know the defendant before would have trouble telling if he was acting?
Mr. Stay.
You can't tell us whether or not the defendant was cut at 9:15 or 9 o'clock, can you?
You didn't see him physically on that date, did you?
No, I did not.
All right, that's the only testimony that's in the record, counsel.
Did the defendant tell you what he was wearing at the time?
Nope.
Overruled.
Tell you whether or not he had a pair of gloves with him at the time?
Overruled.
Now, you and the defendant, you plan to go into business together. Is that right?
That's not right.
Well, you had a prototype of a certain exercise contraption made. Is that correct?
That's correct.
And what was this contraption called? Or did it have a name?
We hadn't given it a name yet. We're going to call it something like the exerciser or something like that.
Or the Porta Gym or something like that?
Porta Gym. Yeah, it was like one of the names that we flew around. Yeah.
Okay, when did you have that prototype made?
That was in February '94.
And you and the defendant had discussed producing this item, hadn't you?
Overruled.
If the video would be a success, and that was a possibility.
Okay, so my question is, you and the defendant had discussed producing this particular item, is that correct?
Possibly, yeah. We had possibly discussed to possibly produce it.
Will you possibly discuss something? You had possibly discussed?
No, we discussed to possibly produce the item.
Okay. You discussed producing the item prior to your having the prototype made, is that right?
Yeah.
Okay. And you did have the prototype made in February '94.
Mm-hmm.
Is
For
that
the
correct?
video. That's correct.
And you were going to include that exercise gadget or contraption with the video that you say that you and he were going to produce for Playboy. Is that correct?
We weren't the ones making that decision. Playboy would be the one making the decision.
Okay, but you were going to offer or suggest to Playboy that they include your exercise gadget along with the video?
That's correct.
Now, I take it you weren't going to give this exerciser to Playboy for free. Is that correct?
That's correct.
You and the defendant were going to manufacture these items, correct?
If Playboy would accept it, yeah.
Okay, and you were going to sell them to Playboy. Is that correct?
Yeah.
Now, in May and June of 1994, you and the defendant were planning to manufacture 100,000 units of this prototype. Is that correct?
Possibly, yeah, if it would be included in the video.
Okay. Well, you were discussing the production of 100,000 of these units.
Yeah, not the defendant and I, actually the person that helped me manufacture it, yes.
Okay. But you and the defendant were discussing the production of these as well, correct?
Yeah, but not of 100,000 pieces.
The defendant was going to kick in some money into the project?
Nope,
You never discussed with the defendant him putting up money
Nope.
for this project?
nope. I was going to put up money.
You were going to put up the money to produce 100,000 units.
Yes.
And you had that kind of money.
Sustained.
Did you have that kind of money, sir?
Sustained.
We wouldn't have made up.
Sustained.
Okay.
Well, have you produced this item?
Nope.
In fact, you were talking to someone about producing this item all the way up to the last week before Nicole Brown's murder. Is that correct?
Probably, yeah.
Okay. That's it for today. This guy doesn't matter. This guy doesn't matter one bit. I have no idea why they called him. It doesn't matter why they called him. He's like... None of you watch Naruto. So he's a filler episode, which doesn't mean anything to any of you guys because you don't watch anime. Animes have these storylines. Okay, I guess a lot of shows do. They have the main storylines and they have these little filler episodes that have nothing to do with the story. They're just content. That's what he is. He's just content. He's not part of the storyline at all. Maybe he is. Maybe something big is going to break tomorrow. We'll see from this guy. But I don't think so. We are going to give up for today. And we're going to start again tomorrow. I hope that you guys have a great day. Thank you so much for coming out. We're getting to the end, which makes it so exciting, which makes stopping the stream harder. And I can't wait to start the stream. Sometimes when I'm in my first stream, I'm like, come on, let's get to OJ. Let's go. But tomorrow's another day. Have a great day, guys. Thank you. Bye.